Did you get a random court date from a collection agency? Or maybe you started with credit repair and you just start getting random court dates from collection agencies. Well, I understand that that can be super scary, but in today's video, I'm going to give you 3 different strategies that you can win this case before even going to trial. Guys, stay tuned. Welcome back to the channel, guys. If you're new to the channel, I'm Credit Coach Q, and I create the first cloud-based software that allows you to put your credit repair experience into your own hands. If you're new to the channel, I'm super excited because I have a banger. In today's video, we're going to talk about 3 different strategies that'll help you win your court case with your collection company. But before we get into the channel, guys, please like and subscribe to the video. It allows YouTube to push this content to a wider audience, and also allows YouTube to push us within their algorithm a little further, and allows us to leave these lights on. Guys, please like and subscribe to the channel. If you have anything derogatory in your credit report, I mean anything negative, charge-offs, late payments, bankruptcies, medical bills, guys, you name it, please go over to mycreditapproved.com. It's the website and the software that I was telling you about that allows you to put the full experience to your own hands. Guys, people are removing thousands of dollars worth of debt by themselves. They are no longer using credit repair companies. They are putting this information and this experience into their own hands and appreciating on a deeper level. Guys, please go to mycreditapproved.com, check out the software, and start removing these items, guys, if you have anything derogatory on your credit report. Now, let's dive straight into the meat and potatoes of this video. Guys, I'm super excited about this video because this video is going to help so many people with this type of situation. A lot of people are looking to get their credit fixed, and once they start on the credit journey, they start getting summons to go to court. Now, these can be scare tactics or these can be very real, but all the same, guys, this video is going to help you not only have confidence to beat this, but to actually win the case before going to trial. Now, let's dive straight in. So first and foremost, if you have anything negative on your credit report, you should be going to My Credit Approved. You should not be dealing with anything that's negative as far as collections, charge off, late payment, medical bill. All of that minutia needs to be removed from your credit report ASAP. And if you haven't started that journey, you need to go to My Credit Approved, the app, and actually get it removed yourself, guys. It's the #1 app in credit repair right now, and it is very easy to use, and is very user friendly as well, guys. Go to mycreditapproved.com. Now, in regards to this case, let's dive straight into how to tackle this case. Okay, first and foremost, first thing you want to do when it comes to getting to winning this case is, guys, relax. A lot of people, you know, do crazy things because they get frantic. They get pretty scared about a court case and they just don't know what to do. A lot of people make a very common mistake. Actually, 95% of people do this one thing. They do not go to the court date. A nationwide study indicated that 95% of people that get served like this never go. Now, that is one of the worst things that you can do in this situation. Is literally is the worst, because you are subject to the highest penalty in the worst case scenario when it comes to your case, without you even actually being represented properly. Guys, do not go to this. You want to go to the court date. That is the first thing that you need to do, is go to the court date, because without the court date, they are automatically going to win. And these institutions know that 95% ratio. They know that a lot of people do not go to the court dates, and they are looking for you not to go to the court date. They're looking to scare you off, and they're looking to not see you there when it's time for you to go to court. And a lot of times, the attorneys don't even show up. A lot of times, they just send you a document with a real court date on it, and then when you go to the court date, a lot of time their representation is not there. So at that point, then the judge have an option to dismiss it or extend it, but at the very least, you're not gonna have to deal with it at the present time. Now, going to the court date is very important because the person that's suing you has to pay for representation, has to pay for someone to actually be there, and whether that is a cheap lawyer or expensive lawyer, that is going to be expensive. So actually, it, and going to trial is a whole nother game. Now, if you don't have a very large debt, I mean between $20, $30, $40,000 worth of debt, then I don't think that an institution is going to invest that type of money into your particular debt. Now, they might want to invest to send you a summons for a court date, because a lot of times 95% people do not go. They can get the judge to do basically whatever to the file, and they can ultimately get their payment back and whatever, because now you have a judgment, and judgments are harder to remove than a traditional collection or a charge off. So yes, they are waiting and hoping and praying that you do not show up. So showing up is literally going to save you so much time, because you don't even realize how much people lose out on in regards to these cases just because they don't show up. So first, foremost, show up. Number two is going to be very easy. It's called the statute of limitation. Now, all debt in this country have a statute of limitation attached to it. And the statute of limitation is basically a time frame of when they can take the debt. It's a time frame. Now, the statute of limitations on all debt on your credit report is 7 years, but it's actually 2 statute of limitations. It's one for your state and one for all credit reports. The one for all credit reports is 7 years, but the one for your state can be 4 years. It can literally be 3 years. I think the statute of limitations in Texas is 4 years. So if you had a debt on your credit report for 5 years, and for 5 years, and it's over the 4-year mark for when companies can collect from that state, then they are already past the statute of limitations, and a lot of these cases get thrown out from the statute of limitations. Statute of limitation is very powerful because it is actually legally binding. So when you have any debt on your credit report, the first thing you want to see is how long is it and how long it's been there. Now, statute of limitation starts, guys, pay attention to this, is very important. The statute of limitations starts on the last time you paid any of the debt. So the statute of limitations do not start when the debt actually happened. It don't start when you open the account. It starts when the last time you paid the debt. So if you had an account for 6 years and you paid $1 towards that account, you will start that statute of limitations completely over. So instead of waiting another year to get it completely removed from your credit report, because the statute of limitations is only 7 years, you have to wait an additional 7 years because it's starts on the last payment date. So if you had this payment for a long time and you are paying payments towards it, that's a very bad idea, because you're going to have to wait 7 years to get it removed from your credit report. And on top of it, you're going to basically keep starting the statute of limitations mark over. So if you have a court date, the first thing you want to do is look at the statute of limitation. You want to see exactly when the debt was open, how long it's been open, and basically compare that to the date that they are suing you. Compare and contrast. And if you are seeing that the statute of limitations is up for the state or for the placement of on your credit report, then you can ask the judge to dismiss it. What you want to do is file a motion to dismiss. Now, everything I'm teaching you guys, you do not need a lawyer present. This is not financial advice either, but all these practices you can be done singularly. You do not need a attorney or any representation to do any of these practices. So if you see that the debt is older than the statute of limitation mark, you want to go and file a motion to dismiss. It's basically a written motion to the judge explaining why you want the case to be dismissed under the merit of statute of limitations. So guys, the first but not least is statute of limitation. I know I said first was actually showing up, but the first is statute of limitation as far as the hack and strategy. Now, number two is going to be the most powerful. Now, I don't know, statute of limitation is pretty powerful, but number two is as powerful or a little bit more powerful, and that is finding the loophole of arbitration clause. Let me explain. So most of these financial institutions make you sign what is called an arbitration clause. Now, arbitration is basically a mini courtroom without a judge, but an arbitrator that's basically filling in for a judge to review the case without any lawyers, without any type of trials, without any type of anything like that. So it's basically an arbitrator. You go to a small room, talk about the case, and the arbitrator will make a decision on who wins the case. And when you sign these documents, most of these credit documents have arbitration clause to protect them. So if they make a mistake by selling you a vehicle, or if they make a mistake by taking money out your account, they don't want to get sued. sue. So they basically have a clause in place where they can ask for an arbitration to be done instead of a trial, and both parties can request that. And that's what you're going to do next, guys. You're going to go and find and tell the judge that you have an arbitration clause and you want to entertain it. You want to basically file for arbitration. Now, you're probably thinking like, what happens if you get arbitration? I might lose. They're not going to go to arbitration with you, guys. Arbitration is very, very expensive. Just for an arbitration to happen, it can cost between $35,000 to $5,000 just for them to even get in the room with the arbitrator. And if your debt does not exceed that amount, then I don't think that they are going to pursue you. In all actuality, I've seen a lot of cases get dismissed just because they didn't have, it just wasn't worth it for them to pursue a case that will cost more to fight opposed to actually get on the back end. So guys, an arbitration clause is very, very powerful because people don't understand that you can request it anytime. And once you request it, the judge have to dismiss the current case and abide by your request for an arbitrator. And once you do that, guys, you can almost count the days for them to dismiss the whole thing entirely, because at that point it's just not worth it. Now, that's number two. Number three, last but not least, is settlement. Now, I really don't like that. I don't like this option. Less than 2% of our clients actually settle these type of situations, only because it's not worth it. A lot of times, I say probably 97% of the time, the first two methods will work prior to you even getting to this stage. But if you are a rare occurrence for this type of situation, you actually do get opportunity to settle, then you can. I mean, depends on how much it actually is. If you can get this debt on pennies to the dollar just to make them leave you alone and get it removed from your credit report, then it might be worth it to you. I know people pay us a lot of money just to remove, $10,000 to $15,000 worth of debt. And if that's the case, then it might be, in your best interest to settle for $3,000. If you have a $15,000 bill and they settle for $3,000, then you win and they win. They get money. They don't have to fight. They don't have to pay to fight, and the case is resolved. So yes, guys, settlement is always an option. It's not my best option, but it is an option to get these guys taken care of prior to going to trial. Guys, let me know in the comments how you feel about this. Do you feel like you have tried these methods? I highly doubt anyone tried these methods and it not worked. Again, if you need any credit repair, go to mycreditapproved.com. Let me know in the comments how you feel about this. If you have any additional questions for your particular case, let me know in the comments and I'll see if I can help. Guys, until next time, take care of your credit and take care of yourself. Credit Coach Q out.